there, I'm Ian Charles of Wizards, and I'm here with Jeremy Holt. Jeremy, please introduce yourself.
Hi, I'm Jeremy Holt. I am a partner in Clark Holt Commercial Solicitors based in Swindon. I spend about half my time dealing with commercial law and the other half of my time dealing with IT law. I've written a thoroughly dull book on the subject, which is here, which is available at all bad bookshops.
Including Amazon, I'm sure. What's the difference between commercial law and IT law? What's the distinction you're drawing?
IT law is a subset of commercial law.
Right.
Commercial law is the widespread part of it. One of the things that are covered by commercial law would be IT law. Some people argue that there isn't such a thing as IT law. It's really just contractual law and intellectual property law, but it's a bit of a sort of pointless discussion, I think. But
yes.
When people ask me what I do, if I explain that I spend half my time advising on IT law, that seems to get the message across. So they think I'm dealing with terribly glamorous hacking cases, when in fact it's mostly system sale agreements.
Yes, system sale agreements. It's what, integration and the like, right? System integration. Okay, well, we're here today to talk about some common IT or mistakes in IT. Where do you want to start with that?
Okay, I'll give you an example of something which happens to me quite often. I'll be sitting at my desk and someone will ring up, generally quite angry, not angry at me, angry at someone else. And what will have happened is that someone will have commissioned a website from a website developer, and later they will have fallen out with the website developer. And either the website developer wants to be paid money for work they've done so far, or won't make any further changes without further payment. And the person on the phone to me is the owner of the website, who sort of says in a loud voice, "I paid for this, therefore I own it, don't I?" And of course it doesn't work like that, because the copyright in the source code of the website will belong to the developer, and it will only be assigned to the website owner if there's a deed of assignment assigning it over. Otherwise, all that the person who has got the website has is an implied license to use that copyright. Often there's no agreement. I then ask if there's an agreement, and they say no, so you just fall back on what the general law implies. And I then say to the angry person on the telephone, I hate to break it to you, but you have a choice of two different courses. You either succumb or accept what the website developer is asking for, because then they will give you the source code if you want to get someone else to develop it further, or if you want the website developer to make changes. That's option A. If that sticks in your craw too much and you don't want to do that, then I'm afraid you're going to have to find another website developer and start from scratch and put that up on the web.
But the whole point about licenses is that when you buy a copy of, I don't know, Word or Adobe Studio or whatever it is, all you're getting is the license to use the software.
You'll get the source code. You'll get a license, a limited license, either by time or area. To use it. You won't get the actual ownership. There's a big difference between the ownership of Windows and a license to use Windows.
Absolutely, and what you could physically do with it. So it's a license to use rather than if you make any changes to that, then that's very much at your risk.
Yeah.
Okay. So what about things like the use and abuse of images?
That's another call that I get quite often. Somebody's received a letter from the owner of some copyright in an image. Sometimes it's Getty Images, which you've mentioned already.
Though not in this video.
All right, I'm sure you mentioned it to me, but I realise that my memory is remiss at this point. Okay, they receive a letter from somebody saying, "You appear to have used our copyright in your website. Please pay us this amount of money."
In your website. What about in your emails?
Can do. Less often.
What about an image you may have used on a public on a social media site?
Social media, yes. They would either use it on the internet or on social media. Social media, not quite so much, because I think, but particularly where they're using the image for commercial purposes as opposed to just personal purposes. The copyright owner will write and demand some kind of payment for the unauthorized use of that. Now, the mistake that people make is to think that everything that's up on the web does not is not protected by copyright. It is, merely because the copyright owner has chosen to put it up on the web, doesn't mean that they've waived the copyright in it. And so, by law, the copyright owner is allowed to contact the person who is illicitly using that copyright and demand a reasonable payment for being allowed to do that.
So on the images that I use on our website in our emails, I have a subscription to a competitor of Getty Images.
I'm so pleased.
Who may be who are actually called graphic stocks, but that's a
Right.
whole other story.
Other suppliers are available.
But the beauty of that is that when I'm viewing the image on their website, it is watermarked.
Okay.
So and because I've got a subscription, I download the image and that's watermark free. That's then free for me to use in the pursuance of Wizards Limited's business.
Yeah.
Right. So that's the difference there. If I go along to someone else's website and you take that image and so on, what about things like doctoring images? Say I come across a picture of a photograph of somebody, so maybe a famous Swindon solicitor, and
it needs doctoring.
yeah, well, and maybe sort of add a moustache and some devil's horns and the like. What's the if I do that in Photoshop, which is actually very straightforward process to do.
Yeah.
Maybe a tattoo with cut here,
Right.
that sort of thing.
If there's a recognisable part of the new image has a new copyright, but if there's a recognisable part of the old image in the new image, that will be in breach of copyright. If they started with the old picture and they simply adjusted that, unless they adjusted everything, in which case it would be a new image.
Well, exactly, yeah.
But if there's any part that's recognisable from the old part, that would be in breach of copyright.
Right. So that's the distinction there, isn't it? So if it's recognisably said solicitor, it's a high-profile solicitor from the Wiltshire area.
Most solicitors in Swindon have horns, in my experience. I hope I'm not letting too much out of the bag.
Absolutely. We'll let we'll later rest the small matter of the tail. Are there any other common mistakes that people make in the IT sector?
Yes, I mean obviously a lot revolves around cloud now, and one of the things which I lecture to other lawyers about is how cloud actually works. Now, the thing to remember about cloud is that cloud would only ever happen when there was massive bandwidth and when there was cheap storage.
Yeah.
And what cloud does, the most common example of cloud, there are other types of cloud, but the most common example of cloud is software as a service. And so some people think, well, therefore you need a license. It isn't. That isn't the case. You don't need a license, because software as a service is the provision of services. So the software is being run completely within the confines of the cloud supplier. It's not being run on the premises of the user. So the user is sending messages across the wide bandwidth for instructions to use the software there. But because the software is totally used within the confines of the cloud supplier, it's the provision of services and not the license of software.
Right, so we're then into the realms of the fact that the license is then owned by the cloud,
That's right.
The license to
so
use.
If you went to a cloud supplier and say, hey, I use this unusual software, I use XYZ software, what would happen is that the cloud supplier would go and get a license to use XYZ software. So they would have a right to use that software, and then they would provide services. They would process data for the customer. Now, the customer might have used that software originally. They might give up that software. There might be an assignment of the software to the cloud supplier. All that the software supplier wants is to be paid for the use to use the software. They don't mind who actually uses it.
And then, of course, we've got the further distinction of the private cloud, where the software owner runs it up himself in
Can do. That's another
in
variant.
a platform as a service
Yeah.
solution that he himself effectively rents.
Yeah.
And he then uses that to deliver his own service. Okay, well, I mean, the whole point with the cloud per se is it's a new area, and it is well, it's not complex to understand, but the idea of it is divorced from what we've traditionally.
Exactly.
I mean, when people ask me about what constitutes a cloud service, well, do you know about LinkedIn or Facebook? Well, you don't own the software.
Yeah.
You don't own the hardware it runs on. You don't know where it is.
Yeah.
It doesn't matter. You just access that as an application, and someone else drives it forward.
You show a large degree of understanding.
Yeah, I've been doing this for a while.
That surprises me.
Absolutely, absolutely. Okay, well, is there anything else we could add here?
Yes, I'll give you a few examples. I'm just looking at practical examples that I deal with, so it's not the recherche stuff, but just the sort of more common or garden stuff. I can remember years ago when the internet first came in, and lots of people wanted to know whether you could make contracts via the internet. And of course the internet is a fantastic way of making contracts because it's very difficult to fiddle some of the internet records. And I'm sure when telex came in and fax came in, people would have asked at that point whether you can make contracts by fax or telex. And the answer was yes, and so you can in relation to internet. But we've largely got over that. Now one of the other things is that when people were allowed...
Fax is slightly different because there's hard copy at both ends, isn't there?
There should be if there's paper in the machine at that point, which
exactly.
most of the legal cases about when there was no paper in the machine, so they never got it. It's all about delivery of the acceptance. A common law school question, university question. Now, the other thing is, when you allow your staff to access to the internet, you're going to need to have a few rules about that, because you don't want them the staff just sitting there all day booking their holidays and doing all the other things that they can do. So I can remember when the internet first came in, I was approached by a managing director who was quite a religious kind of chap, and this is relevant for what I'm later about to tell you. And he discovered that one of his salesmen, well, it would have to be one of his salesmen, used to go into the office at weekends. Not to be confused with Swindon Solicitors. One of his salesmen used to go in on a Saturday and download Swedish porn. Well, I can tell you how long ago it was, because it took most of the day to download the Swedish porn. And the managing director was absolutely incensed about this. And he even gave me the PC for sort of evidential purposes, wrapped up in cling film, as if that was in some way to sort of keep the porn
sterile.
There. Now, the problem was we had laid down no rules about what the staff could do with the internet access that they had, and the salesman rather unwisely used a company credit card to pay the Swedish porn supplier for the porn. And for that reason, we were able to get rid of him, because he was using the company credit card for illicit purposes. We also contacted the Swedish porn supplier. Well, I had to have some excuse. And never have I seen someone refund the money quicker than the Swedish porn supplier in those circumstances, because we said that he had no authority to pay for this stuff with it. But the point of this story, and there is a point of this story, is if you have no rules, it's very difficult to show that anyone has broken the rules, unless it's being absolutely ridiculous. So there is now, if a company's staff have access to the internet, you do need a policy of some kind to say what they can and can't do. Now, I tend to be quite liberal about these things, because I think it's better to allow them to have access and to do personal searches and to research things themselves. What I always say when I'm lecturing about this is that the employer's biggest allies are going to be the other staff, because if there's a member of staff just looking up horoscopes or something all day and not doing their work, and other people having to do more work as a result, then somebody will eventually tip off the employer there. So in the policy, you might reserve the right to monitor it in restricted circumstances for computer security or for safety or things like that. But my general policy, my general advice to employer clients is let people do what they want, because if they're going overboard on what's happening, you're likely to have found about it. So we normally say you are allowed to use the internet for your own purposes, as long as it doesn't affect your ability to carry out work there.
Okay. Well, why don't we leave it there for now? That's a really interesting point, and we'll go on to say more about that in a moment.
Okay.
Thank you, Jeremy. We'll sign off. Thank you.